Hello, and welcome to our blog and audio series, Defending the Algorithm. This edition was authored and narrated by me, Acacia Perko, a Pennsylvania business and IP trial lawyer with Houston Harbaugh, with researching and drafting assistance from OpenAI's ChatGPT-5. This series explores the evolving and intersections of artificial intelligence, intellectual property, and the law. GPT-5 may generate errors, but I have verified all facts and analysis for accuracy and completeness. Defending the Algorithm, a Bayesian analysis of AI, litigation, and the law. Chapter 1. How businesses can protect innovation in the age of machine intelligence. In our continuing Defending the Algorithm series, examining AI litigation and emerging risks, we now turn to trade secret protection. Following the previous analysis of the Anthropic copyright settlement, which deemed the training of LLMs on legally obtained copyrighted materials as fair use, an important question arises in the other direction. What are the real odds that trade secret law will protect AI innovation? Let me pause here for a moment. Until recently, trade secret protection for AI systems was mostly theoretical. We all understood it could apply, but no one knew exactly how. What makes the OpenEvidence case so important is that it gives us our first real-world look at how courts will apply these laws to AI innovation. It's our first true data point in testing where the boundaries are. Chapter 2. Trade secrets and AI collide in OpenEvidence versus Pathway Medical, Inc. Artificial intelligence is reshaping industries, from healthcare to finance to e-commerce. It's also reshaping how companies protect innovation. The OpenEvidence lawsuit, filed in February of 2025, case number 125-CV-10471, U.S. District Court for the District of Massachusetts, Judge Myung J. Yong, represents the first meaningful test of whether the hidden architecture of an AI model, specifically its AI system prompts, can qualify as a trade secret. These prompts are the embedded instructions set that shape how large language models, or LLMs, reason, respond, and maintain consistency. They're the rules of engagement written by developers to control tone, structure, and behavior, never visible to the end user, but critical to how the model functions. The case also breaks new ground by asking whether so-called prompt injection attacks, or queries deliberately designed to trick an AI system into disclosing those hidden instructions known as AI system prompts, amounts to trade secret misappropriation. In essence, the court is being asked to decide whether manipulating an AI's interface can constitute digital theft. In the 143-paragraph original complaint, plaintiff OpenEvidence alleges numerous federal and state claims, including misappropriation of trade secrets under 18 U.S.C. Section 1836 et sec, violation of Computer Fraud and Abuse Act under 18 U.S.C. Section 1030, breach of contract, violation of Digital Millennium Copyright Act under 17 U.S.C. Section 1201, and unfair competition and unfair deceptive acts in conduct of trade or commerce under Massachusetts General Law, Chapter 93A, Section 11. In sum, plaintiff claims that defendant Pathway Medical, Inc. intentionally exploited its AI platform through a series of engineered prompts to extract proprietary instructions, later using them to accelerate development of a competing medical AI product. Defendant, in turn, argues that no trade secrets were taken, claiming that the AI system prompts, once exposed through user interactions, lose any reasonable expectation of secrecy and fall outside traditional trade secret protection. For those unfamiliar, A prompt injection is when someone uses carefully worded queries to get an AI to reveal its internal instructions, the hidden code that tells it how to think. For AI developers, that's often the most valuable, confidential part of their system. So here is what is really going on in this case. Plaintiff OpenEvidence claims its competitor, Pathway Medical, used prompt injection attacks, basically tricking the AI into revealing its hidden instructions. Those instructions are what make the system unique, the secret sauce that drives its performance. So the question is, when someone extracts that through clever prompting, is it misappropriation or just permissible reverse engineering? That's the heart of this dispute, and it's the first time a federal court will weigh in. Chapter 3: A Modern Framework. Updating our odds of protection. In traditional trade secret cases, protection is often viewed in binary terms. Either information is secret or it isn't. But AI complicates that equation. Borrowing from Bayesian reasoning, a concept foundational to modern AI, we can think of trade secret protection as a prior probability that evolves as new facts and case law emerge. Each decision, like OpenEvidence, provides data that helps businesses and their lawyers update their understanding of how courts are likely to treat AI-driven innovation and its intersection with data privacy. Before OpenEvidence, the idea of protecting AI systems under trade secret law was like a model trained on incomplete data, theoretically sound, but untested in the wild. The doctrine fit AI systems well on paper, but lacked real-world examples of how courts would treat the secret inner workings of an algorithm. Now, as judges begin to grapple with whether AI system prompts qualify as trade secrets, we're finally seeing those theories tested in practice. This section introduces a useful analogy: Bayesian reasoning. The idea is that, just like AI models learn from data, lawyers and businesses can update their understanding of the law as new cases come out. Each case, like OpenEvidence, becomes a piece of evidence that helps us refine how we protect innovation. It's a practical, data-driven way to think about legal strategy, and it reflects how the field of AI itself operates. Chapter 4: Why Trade Secrets Are Becoming a Go-To for AI Innovation. Copyrights and patents come with significant AI-specific limitations. But the law on patent eligibility in particular is rapidly evolving as the technology advances. The U.S. Copyright Office refuses to register works created entirely by AI. The USPTO requires human inventors, and courts frequently reject patents where AI contributions can't be separated from human invention. Although this trend at the USPTO may be in the opposite direction as AI becomes more ubiquitous. By contrast, trade secret law doesn't depend on authorship. Under both the Pennsylvania Uniform Trade Secrets Act, found at 12PA.CS section 5301 at SEC, and the Federal Defend Trade Secrets Act, found at 18 USC section 1836, a trade secret is protectable if it 1. Derives independent economic value from remaining secret, and 2. Is subject to reasonable efforts to maintain secrecy. That flexibility makes trade secrets particularly useful for protecting data that may not qualify for copyright or patent protections, or which inventors do not wish to disclose in a public patent application or issued patent, such as model architecture and algorithms, training data and methodologies, system prompts and fine-tuning instructions, and proprietary output structures and response frameworks. Here's a teaching point. Think of trade secrets as the secret recipe of AI innovation. Coca-Cola never patented its formula, yet has protected it for over a century through secrecy. AI developers can do the same if they treat their data, prompts, and methods with the same rigor. This is where I like to remind clients that trade secrets can often be faster and more flexible than patents and copyrights. You don't have to register anything, and you don't need to prove human authorship. But, and this is key, you do have to treat your data and your systems like they are genuinely secret. That means locking down access, limiting disclosure, and keeping your internal documentation clean and up to date. Chapter 5: The OpenEvidence Case, Testing the Boundaries. OpenEvidence Inc., based in Massachusetts, developed an AI tool that provides medical professionals with real-time answers to clinical questions. Its value rested on carefully crafted AI system prompts, hidden instructions that guide the LLM in how the AI reasoned and responded. In its original complaint, plaintiff OpenEvidence Inc. alleges that the AI system prompts have independent economic value by claiming in their complaint, quote, "The system prompts its code that provides the LLM with its core and critical background and situational context. A system prompt also sets the LLM's role, personality, and subject matter expertise. And it contains a set of governing rules and boundaries for interacting with users and providing responses. It is the constitutional framework of any LLM, and it is accordingly a proprietary and extremely valuable asset for any AI company." End quote. From the original complaint, paragraph 3. Further, plaintiff alleges that its competitor, Defendant Pathway Medical Inc., intentionally probed its system through prompt injection attacks to extract those instructions and speed development of its own competing product. The case alleges violations of the Defend Trade Secrets Act found at 18 U.S.C. Section 1836, the Computer Fraud and Abuse Act found at 18 U.S.C. Section 1030, breach of contract from the terms of use, and unfair competition under Massachusetts GL Chapter 93A, Section 11. Defendant's motion to dismiss, filed on June 16, 2025, argues that OpenEvidence failed to allege access to any non-public information, contending that prompt injection through a public interface is simply lawful reverse engineering, which can be a strong defense to claims of trade secret misappropriation. In its amended complaint, filed August 21, 2025, plaintiff OpenEvidence reframed the dispute as an elaborate conspiracy to steal proprietary AI technology through unauthorized access and systematic data extraction. The case now awaits further proceedings, with defendant's response due October 28, 2025. Here is the key legal question. Can AI system prompts remain protected as trade secrets when they're potentially discoverable through clever user interactions? Is tricking a model into revealing its internal logic an act of misappropriation, or just permissible competitive investigation? So here's where the case gets really interesting. OpenEvidence alleges that Pathway used targeted prompts to steal their internal AI instructions, while Pathway argues they were just using a public-facing tool and figuring out how it worked. The line between smart competition and digital trespass has never been thinner. And the way this court defines that boundary will have ripple effects across every AI developer in the country. Chapter 6: Understanding the Risk, What OpenEvidence Tells Pennsylvania Businesses. From a practical standpoint, OpenEvidence offers a real-world data point to help Pennsylvania businesses recalibrate their expectations. Courts are actively considering whether prompt injection equals improper means under trade secret law. The case highlights that website terms of use alone may not be enough protection. Technical controls and audit logs are critical. And the likely success of similar claims depends on whether plaintiff trade secret owners can show reasonable, documentable efforts to protect AI trade secret assets. If we think in Bayesian terms, this case nudges our posterior probability of enforceable AI trade secret protection upward, from theoretical optimism to cautious realism. The odds are improving, but the burden of proof remains somewhat confusing and likely rather steep. For Pennsylvania companies, this case is a wake-up call. It shows that courts aren't going to take your word for it that something is confidential. They're going to look for proof. Proof in the form of access controls, logs, system policies, and real documentation. In other words, reasonable measures under the Pennsylvania Uniform Trade Secrets Acts now means technical as well as contractual safeguards. Chapter 7: Practical Strategies for Protecting AI Trade Secrets. For Pennsylvania businesses deploying AI enterprise software, protection requires both prevention and proof. Courts will ask, what did you actually do to keep it secret? 1. Segment and define. Identify and categorize what constitutes a trade secret within your AI ecosystem: prompts, architecture, or data. Document the economic value of that secrecy. 2. Implement access controls. Restrict internal and external access to AI system components. Maintain detailed logs, enforce role-based permissions, and deploy rate limits to prevent data scrapping. 3. Strengthen contracts. Ensure your terms of use, NDAs, and vendor agreements explicitly prohibit reverse engineering and unauthorized data extraction. 4. Monitor and detect. Track unusual query behavior that may signal prompt injection or scraping attempts. Document each incident. Contemporaneous records are key evidence of diligence. 5. Manage training data. Avoid training AI models on confidential data that may surface in outputs. Maintain data provenance and segregation between proprietary and public sources. Here's a Pennsylvania note. Under the Pennsylvania Uniform Trade Secrets Act, courts focus on reasonable efforts under the circumstances. This requires more than policies. It demands demonstrable technical and procedural safeguards. Merely relying on contract terms may not meet the threshold. This is the section that gets the most practical. And frankly, it's where businesses can get ahead. Start by defining exactly what your trade secrets are in your AI stack: architecture, prompts, training data, or fine-tuning processes. Then make sure only those who truly need access have it. And always track who's querying your models and how. These kinds of digital paper trails are what will protect you in court later. Chapter 8: Trade Secrets versus Patents and Copyrights. Current status. Looking at the types of protection, we will address the AI applicability, strengths, and limitations. First, copyrights. Human authorship is required. Their strengths: they protect human-authored content. And limitations: there's no protection for solely AI-generated works. Looking at patents. Patents required human inventors only. Their strengths: there are strong rights for qualified inventions, but there are some limitations. Public disclosure is required and often denied for AI-related methods. Looking at trade secrets. Their value is from real secrecy, not authorship. Their strengths, there's no expiration, and they're flexible in scope. Their limitations, they can be fragile if information is leaked or reverse engineered. Here's the teaching point. Patents are like a visible fence. Everyone can see what you own. Trade secrets are buried treasure. They only remain yours as long as no one else digs them up. I often explain it like this. Patents are like fences. Everyone can see what's inside, and that visibility gives you rights. But trade secrets are more like buried treasure. The value lies in the fact that no one else can find it. In the AI space, where transparency and sharing are common, this tension is what makes trade secret law both powerful and fragile. Chapter 9: Pennsylvania Trade Secret Law and AI Protection. Pennsylvania adopted the Uniform Trade Secrets Act in 2004, providing robust protection for confidential business information. Courts evaluating AI-related trade secrets will focus on three questions. 1. Were reasonable protective measures implemented by the owner? 2. Was the information readily ascertainable through lawful means? 3. Did the alleged misconduct cross the line from competitive intelligence to misappropriation? Given the state's strong precedent on confidentiality and the growing use of AI in regulated industries, Pennsylvania is poised to become an important jurisdiction in defining trade secret boundaries for AI systems. Pennsylvania's legal landscape is especially relevant here. We adopted the Uniform Trade Secrets Act back in 2004, and with Pittsburgh's technology ecosystem, from Carnegie Mellon to the startup community, it's becoming a hub for AI litigation. That means the standards we're set here could influence how other states interpret AI-related trade secret disputes. Chapter 10: Key takeaways for Pennsylvania businesses. 1. Trade secrets are a natural fit for AI. They can protect algorithms, training data, and prompts with or without human authorship. 2. But they are fragile. Prompt attacks, employee mobility, and interface access can all erode protection. 3. Case law is developing. OpenEvidence may become a landmark on whether prompt injection counts as misappropriation. 4. Layered strategies are essential. Combine trade secret protection with contracts, patents, and technical safeguards. And 5. Reasonable measures are the key. Pennsylvania courts will expect more than NDAs. They'll look for tangible, documented steps. Chapter 11: Conclusion: Balancing AI power with secrecy discipline. AI innovation operates in a paradox. Systems built to generate and share information must also safeguard it. OpenEvidence reminds us that trade secret protection is not automatic. It's earned through proactive measures, technical rigor, and continual reassessment as technology evolves. The Bayesian mindset, constantly updating your assumptions as new facts emerge to predict the probability of a future event, offers a practical analogy for AI governance. Each new case, each enforcement action helps refine how businesses and their lawyers should evaluate and fortify their own IP protection. Handled wisely, trade secrets can give companies a durable edge in a competitive AI-driven economy. Handled carelessly, they can become litigation liabilities. As the OpenEvidence case develops, Pennsylvania businesses should monitor the progress of this case closely and treat it as a living lesson in how to defend the algorithm. As we wrap up, I want to emphasize this idea. AI innovation lives in a paradox. The technology depends on sharing and learning from information, but success depends on protecting that same information from misuse. The open evidence case reminds us that trade secret protection isn't automatic. It's earned through vigilance, structure, and proof. Handled wisely, trade secrets can give your company a long term advantage, but handled carelessly, they can unravel everything you've built. This article is part of Houston Harbaugh's ongoing Defending the Algorithm series, exploring AI litigation and risk analysis through practical frameworks for businesses and innovators. If you'd like to read the full text of this article, you can find it on the Houston Harbaugh website under our Defending the Algorithm series. And if you'd like to talk more about how your company can build a stronger AI protection strategy, feel free to reach out. My email is perkoab at hh-law.com, and my direct line is 412-288-4016. Again, I'm Acacia Perko, a business and intellectual property trial lawyer at Houston Harbaugh in Pittsburgh, Pennsylvania. Thank you for listening, and we will catch you next time on Defending the Algorithm.